Hey there, I'm the MadCatster. My glad to see you here. Well, I bet you've been wondering what's going on with the TikTok psychic versus the professor and that horrible tragedy that took place with those University of Idaho students. I don't think even Ashley Gillard, the TikTok psychic, could have predicted where we would be right now. I've got some updates and some breaking news in the case. You know I've got the deets and all the receipts, so buckle up and let's go. The circus that is the lawsuit between professor at the University of Idaho and the TikTok psychic Ashley Gillard. It's been one big careening mess. Ashley Gillard has not seemingly learned anything from all of this, continues to buckle down. Well, now in the federal court lawsuit, the professor has filed asking the court to grant her judgment. It's what we call a motion for summary judgment because the professor is arguing that there are absolutely no facts to be determined at trial. Everything is already crystal clear based on the evidence, and she's asking the judge to grant her judgment on her claims of defamation. We're going to go over what she had to say to the judge, and then Ashley Gillard, the TikTok psychic, her crazy response. As those wizened philosophers of the 70s and 80s ABBA once said, it goes on and on and on. It keeps me rocking till the night is gone. So follow me down the rabbit hole. So I am here with Sybil the Enforcer, and not only is Sybil going to ask you to like and subscribe because we are only about 1,000 subscribers away from hitting 30,000. Give us a hand and help us out. But Sybil also is joining me, and so is Edith, to make a special plea to you. It's been, I think, well over a year since I asked you guys to help out with the fundraiser, and it's not for me, but for SOS Rescue down in Georgia that does basically God's work. And in a particular situation that's dear to my heart, and I know to a lot of my viewers' hearts, they saved 28 cats literally from being euthanized and managed to find a no-kill shelter in New Hampshire that will take all 28 cats. Of course, as you can imagine, it's not cheap. It's not free to rescue cats, and costs to get them ready, vaccines, etc., prepare paperwork, and then transport them physically up to New Hampshire. They've started a fundraiser, and I'm going to post a few pictures here of the cats, and they're asking for me to ask you for your help to raise the money to offset the cost of saving those cats and sending them up to New Hampshire. So I'll post a description of their fundraiser and a link to their fundraiser page down below. They are a 501c3 organization approved by the IRS, so your donation is tax deductible as allowed by law. Thank you. Also, I have some bonus content. Stay tuned at the end of this video. I'm going to taste test Oompaville's Sour Boys candy. No, I'm not sponsored. I went on their website. I ordered 2 different flavors. They've now arrived. I'm going to open the packages, not live, but with you here on video and give you my honest opinion about what I think about Oompaville's candy. So stay tuned for that. And I'm also I'll give you an update. My little cat Squirt had to have emergency surgery last week. He's doing fine, but I'll tell you all about that too. I quickly want to thank a few people who sent us generously some stuff from the cat's Amazon wish list, which is down below. I'd like to thank Manic McAllison Cats, and these are some strange names. Stevie Ray Nix Von Heinrich, Hebe the Boogeyman, Raven Hexen, Mina Barker Von Heinrich, and Mace Windu. I'd like to thank them for sending us some catnip mice. They sent us some Blue Buffalo cat food, a case of the wet food. They sent us some Temptations mix-up treats, which the cats love and go through a lot of, so thank you for that. I'd also like to quickly thank Rebecca Z, who sent us a bunch of catnip mice and also some Temptations mix-up soft and crunchy treats. Thank you for that. I'd also like to thank Laureen K, who sent us some Friskies Party Mix, 2 20-ounce containers. She also sent us a nice warm round bed for the cats, and she sent us some Purina Tidy Cats, a big thing of the lightweight litter. I'd also like to thank Laundry Art for sending us another one of those really wonderful collapsible cat carriers. So thank you guys so much. So let's talk about the ongoing mess that the TikTok psychic Ashley Gillard basically brought upon herself by falsely accusing a professor at the University of Idaho of being involved in the deaths of several students from the university, even though there was absolutely no evidence about it. And Ashley Gillard claims that tarot cards basically told her all of this. And there's a lawsuit that's been going on in federal court that I've made a couple of videos about. And Ashley Gillard just continues to double down on what she said. And you'll see in her response to this motion for summary judgment, she says what she thinks is legally viable defenses to this motion, but really aren't. And, I'm a real lawyer. We'll talk about it in a second. But first, let's go over what the professor is asking the court to do. So we've talked about this before, but a motion for summary judgment is basically where you say to the court, based on all of the evidence and the facts, there are no facts in question that a trial is needed to decide. And therefore, we're asking the court to rule on the evidence because we feel that the evidence is complete enough for the court to make a decision and issue a judgment without continuing to go to trial. And so that's what Rebecca Schofield is doing. So here's her motion for partial summary judgment. She says, that she's moving the court for partial summary judgment. As to liability on each of her claims, the motion for partial summary judgment is supported by the memorandum in support, and that's basically you file what briefly is like the motion, but then you do like a memorandum of law, which includes like all of your argument and your reasoning as to why the court should grant the motion. So, and she says, that it's supported by the memorandum in support. It's also supported by Professor Schofield's statement of undisputed material facts, the declaration of Wendy J. Olson, who is her attorney, who Ashley Gillard insanely decided to try to drag into this by, I think she had subpoenaed her, which just bananas, because the lawyer can't be a witness against their own client in a trial, and not to mention the fact that she had absolutely nothing to do with it. I'm going to go over just briefly the most important stuff with you guys. So Rebecca Schofield respectfully requests the court enter judgment on both her claims against defendant Ashley Gillard. As a matter of law and as a consequence of her failure to engage in this litigation as required by the federal rules of civil procedure, Ms. Gillard has admitted to defaming Professor Schofield. Ms. Gillard's admissions establish beyond dispute that Ms. Gillard is liable for her defamation of Professor Schofield. Accordingly, all that remains is for a jury to determine the extent of Professor Schofield's damages. So in other words, it's clear by the facts in the plaintiff's opinion in this case that there is nothing left to dispute and that all of the evidence needed to support her claims and to get a judgment is there. And now they want the court to issue the judgment and then have a jury decide what her damages are going to be. And so background, for those of you who aren't totally familiar, this is a brief sort of synopsis of how we got here. In November 2022, 4 students at the University of Idaho had their lives taken at a home near campus. Ms. Gillard, a resident of Texas, took this tragedy as an opportunity to post sensationalist content online to attract clicks and make money. According to Ms. Gillard, she used her spiritual practice, psychic abilities, and metaphysical tools, including tarot cards, to post over 100 TikTok videos of her supposed findings concerning the deaths near the university. Ms. Gillard's purported findings, which she posted on the social media website TikTok, went like this. Professor Schofield had an affair with one of the students and then planned, initiated, ordered, and executed the deaths of the students. Ms. Gillard has admitted that she made these sensational statements, and she's admitted that these statements are false. Ms. Gillard has also admitted that her false statements are based on nothing more than her spiritual research, intuition, and instincts, and that she has no written information or oral information from another human being that supports her false statement. In a good faith attempt to resolve this matter without litigation and to avoid drawing further attention to Ms. Gillard's utterly baseless statements, Professor Schofield sent cease and desist letters to Ms. Gillard on November 28, 2022 and December 8, 2022. Ms. Gillard received these letters and promptly disregarded them, instead choosing to continue spreading false information for her own pecuniary gain. Given Ms. Gillard's willful disregard of the cease and desist letters, Professor Schofield filed her complaint, asserting 2 defamation claims. One relating to Ms. Gillard's false statements that Professor Schofield was involved in the deaths, another relating to Ms. Gillard's false statements that Professor Schofield was romantically involved with one of the students. And it says Professor Schofield filed her 2-count complaint on December 21st, 2022. Ms. Gillard failed to answer or otherwise respond to the complaint within the time limit called for under the Federal Rules of Civil Procedure, and Professor Schofield filed a motion for default. The clerk entered default on January 27th, 2023. After failing to respond to the complaint and being found in default, Ms. Gillard filed a motion for relief from judgment and an answer affirmative defenses and counterclaims on February 16, 2023, well after the deadline. And she, feigned that, oh, I didn't get it. Basically, what I think, and according to her behavior, what I've observed is she did get it and just said, screw you. But anyways, the court, as I've explained before, often will be particularly lenient with defendants and remove the default. And especially in this case where, stupidly, Ashley Gillard is not represented by an attorney. She's representing herself. And as the old saying goes, anyone who acts as their own attorney has a fool for a client. So after Ashley Gillard did finally file her answer and her counterclaims, the professor filed a motion to strike her answer. And of course, the court did not allow that. It said on April 26th, the court issued a memorandum of decision and order granting her motion to set aside the default. And I won't read the rest of this because it's basically just giving the court's reasoning, and I've kind of summed it up for you why the court decided to remove the default. So on June 6, 2023, Professor Schofield filed a motion to dismiss Ms. Gillard's counterclaims. The court heard argument on Professor Schofield's motion to dismiss on July 21st, 2023, and issued a memorandum of decision in order dismissing Ms. Gillard's counterclaims on August 8th, which we talked about in a previous video. So Ashley Gillard's counterclaims are gone, which means that the countersuit is gone. So that still leaves just the original lawsuit. Ms. Gillard asked the court to set aside the court's memorandum of decision in order concerning the dismissal, and this remains pending apparently, although I seriously doubt the court is going to set aside its decision because I don't see any justification. Then we have the argument. She says, Ms. Gillard's failure to respond to requests for admission conclusively established material facts. And this is one of the procedural things that happens in a lawsuit is you'll send to the other side, basically it's called a request for admissions, where you make certain statements about facts in the case and you ask the other party to either admit or deny. Following service of requests for admission under the rule, the responding party has 30 days to admit, deny, or object to the request. If the responding party fails to timely respond, the matter is deemed admitted. So in other words, by default, if you don't respond to that request for admissions, the things that they are asking you to admit are going to be deemed by the court to be admitted, whether you admit them or not. A matter admitted under this rule is conclusively established unless the court on motion permits the admission to be withdrawn or amended. Professor Schofield served Ms. Gillard with discovery requests, including requests for admission. Accordingly, Ms. Gillard's responses to those requests for admission were due no later than July 2023. To date, Ms. Gillard has not responded to Professor Schofield's requests. Therefore, she is deemed to have admitted the truth of each fact identified in Professor Schofield's request for admission. Professor Schofield has waited patiently for Ms. Gillard to respond, but 2.5 months after her responses to Professor Schofield's request for admission were due, Ms. Gillard has not responded. So even today, now it's more than 2.5 months later, she still hasn't responded. The effect of an admission under the rule, whether an affirmative admission or a deemed admission due to a failure to respond, is clear. And they cite to the rules, and they say a matter admitted under this rule is conclusively established, meaning that there's no question, it's admitted, it's now ironclad that this is considered to be true. Accordingly, concerning Professor Schofield's first claim for relief relating to Ms. Gillard's false statements regarding the deaths of the students, the following facts have been conclusively established by Ms. Gillard's admissions and other evidence. So these are presumably some of the things they asked her to admit or deny. She didn't respond. They are now saying correctly that according to the rules, these things are now admitted to be true facts, okay? And these are some of the things. Ms. Gillard stated publicly that Professor Schofield was involved with the deaths of the students. Professor Schofield was not involved with the deaths of the students. The only basis for Ms. Gillard's public statements that Professor Schofield was involved is Ms. Gillard's spiritual research, intuition, and instincts. So not based on any factual evidence. Ms. Gillard is not aware of any physical evidence linking Professor Schofield to the deaths. There's some admissions here now where they're saying that Ms. Gillard has no written information and has not received any information orally from another human being showing that Professor Schofield ever met any of the students. And they go one by one with the students, and they list just the initials for privacy reasons. Ms. Gillard knew that the Moscow Police Department issued a press release on December 27, 2022, stating that it did not believe that the female associate professor and chair of history department who was suing a TikTok user for defamation was involved in the crime. So the police are saying they've investigated, they have no evidence. In fact, they had arrested a suspect who they believe was the perpetrator. And concerning Professor Schofield's second claim for relief, the following material facts have been conclusively established. Ms. Gillard publicly stated that Professor Schofield had an affair with one of the students. Professor Schofield did not have an affair with that student. The only basis for Ms. Gillard's statement was Ms. Gillard's spiritual research, intuition, and instincts. Ms. Gillard is not aware of any physical evidence showing that Professor Schofield had an affair with the student. Basically, the admissions are refuting all of the things that Ashley Gillard has claimed or insinuated or alleged against the professor. And then part B, the facts conclusively established by Ms. Gillard's admissions demonstrate Professor Schofield's entitlement to judgment as a matter of law. In a defamation action, a plaintiff must prove that the defendant communicated information concerning the plaintiff to others, and that the information was defamatory, and that the plaintiff was damaged because of the communication. A defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting the person's business. Moreover, the Idaho Supreme Court has recently held that a statement is defamatory per se if it imputes to another conduct constituting a criminal offense, as in this case. If the offense imputed is of a type which, if committed in the place of publication, would be punishable by imprisonment in a state or federal institution, or be regarded by public opinion as involving moral turpitude. Under this test, the proper focus of a defamation per se inquiry is the nature of the conduct imputed. And if criminal conduct is imputed and that conduct amounts to either a crime punishable by imprisonment or a crime of moral turpitude, the allegedly defamatory remarks are actionable as defamation per se. And in this case, those elements have been met. Similarly, a statement is defamatory per se if it ascribes to another conduct, characteristics, or a condition that would adversely affect her fitness for the proper conduct of her lawful business, trade, or profession, or impute serious, intimate misconduct to another. Statements that rise to the level of defamation per se do not require proving special damages. Whether a statement is defamatory per se is a question of law for the courts. Admissions made under the rules, even default admissions, can serve as a factual predicate for summary judgment. So they're saying that, as in this case, the fact that Ashley Gillard didn't respond to the request for admission and they now by default are considered admitted, that can be the basis for a summary judgment motion, which is what we have. Indeed, because evidence inconsistent with a Rule 36 admission is properly excluded, summary judgment may be granted solely based on Rule 36 admissions, even where other evidence might contradict those admissions. So they're saying that regardless of whether Ashley Gillard might have had evidence that would have refuted the statements that the professor was asking her to admit to, it doesn't matter, because once by default they are considered admitted, any evidence to the contrary is irrelevant, because that's all the court needs to consider a motion for summary judgment. Professor Schofield is entitled to judgment as a matter of law on count one. Count one concerns Ms. Gillard's false and defamatory statements that Professor Schofield was involved in the deaths of the students. In particular, beginning on or about November 24, 2022, Ms. Gillard posted videos on TikTok in which she falsely stated that Professor Schofield was responsible for, ordered, or was otherwise involved in the deaths of the 4 students. Ms. Gillard's publishing of these videos on TikTok constitutes a communication as a matter of law, and because Ms. Gillard's statements impute criminal conduct for which the punishment is greater than 1 year imprisonment, the statements are defamatory per se. Accordingly, Professor Schofield is entitled to judgment on count one. Ms. Gillard communicated information regarding Professor Schofield to others. It says Ms. Gillard has admitted that she publicly stated Professor Schofield was involved in the deaths of the students. This admission conclusively established that Ms. Gillard communicated information concerning the plaintiff to others. While few cases dwell on what it means to communicate information concerning the plaintiff to others, there is no doubt that Ms. Gillard's posting of videos to TikTok satisfies this element. The element of publication or communication requires the defamatory statement be communicated to a person other than the person defamed. So in other words, to a third party. In both print and internet publishing, information is generally considered published when it is made available to the public. So as soon as she posted them, it was public information, and she's communicated it now to, millions of people out in her audience. Thus, once information has been published on a website or print media, there is no further act required by the publisher to make the information available to the public. Even absent Ms. Gillard's admissions, there can be no dispute that she communicated information concerning Professor Schofield to others. Beginning on or about November 24, 2022, Ms. Gillard posted TikTok videos to her account in which she falsely stated both directly and indirectly that Professor Schofield was responsible for, involved in, and ordered the deaths of the student. Over the following 4 days, Ms. Gillard posted additional TikToks in which she continued to falsely assert that Professor Schofield ordered and planned the deaths of the students. These TikToks put more details to Ms. Gillard's false theory, so it was like an evolving story, basically. As she kept posting, she kept embellishing what she said and like making up more specific facts or details and really weaving quite a tale. These TikToks put more details to Ms. Gillard's false theory, as Ms. Gillard claimed that Professor Schofield and a different student at the university together planned the deaths. So I think once Ashley Gillard realized that there was evidence contradicting her account that somehow the professor had done this, because she had an alibi placing her out of state at the time, so there's no way she could have done it. Then suddenly Ashley Gillard's, mystical intuition told her, oh wait, it wasn't the professor directly. She got somebody else as an accomplice to do it. Convenient, right? In one of her November 28th TikToks, Ms. Gillard included text stating, I don't care what y'all say. This other person and Rebecca Schofield did this, basically. Rebecca was the one to initiate the plan and hired this other person. In all, Ms. Gillard herself estimates that she posted over 100 TikTok videos of her supposed findings in which she communicated her baseless theory that Professor Schofield was in a relationship with a student that broke up and that she initiated the deaths, planned the deaths, and hired this other person to carry the plan out. And Ms. Gillard has continued, and even we've seen in her pleadings, this is true, has continued to make defamatory statements even after Professor Schofield's November 28th and December 8th cease and desist letters. In fact, even after the filing of the lawsuit, she's continued to make defamatory statements, and she's even made defamatory statements in her pleadings that she's filed with the court. Since December 1, 2022, Ms. Gillard has posted additional TikToks stating, among other things, that Rebecca Schofield is going to prison for the deaths of the students, whether you like it or not. She's basically telling people watching, and I'm not worried about Rebecca Schofield suing me because she will be using her resources to fight for criminal cases, and she ordered the deaths. So, that's a fantasy because she's not ever going to be charged. There's not even a scintilla of evidence that the professor had remotely anything to do with or was in any way connected to these students. So, this is another one of Ashley Gillard's fantasies that somehow, ultimately the professor is going to jail. Moreover, Ms. Gillard's TikToks were in fact viewed by thousands, if not millions, I think probably millions, of people. Some of her TikToks defaming Professor Schofield had thousands of likes, indicating that a third party had viewed them. That's a good point, you could certainly go by views, but the fact that interactively people liked the TikTok clearly establishes that it was viewed. So what they're doing here, and I know that they've repeated certain phrases, is because they have to go through like the elements of what's required for the defamation and in order to convince the court to grant the motion for summary judgment. So it says the professor is entitled to a judgment as a matter of law in count 2 because Ms. Gillard admitted to posting TikToks containing assertions that Professor Schofield was in a romantic relationship with one of the students, admitted that those assertions were false, and admitted she had no evidence to support her false assertions. Ms. Gillard communicated information concerning Professor Schofield to others for the same reasons as discussed above. Ms. Gillard's TikToks that contained false assertions that Professor Schofield had a romantic relationship with a student constitute communications concerning Professor Schofield. As a matter of law, therefore, Ms. Gillard has admitted to the first element of the defamation claim asserted in count 2. Ms. Gillard's false statements that Professor of Schofield maintained a romantic relationship with a student are defamatory as a matter of law. A defamatory statement is one that tends to harm a person's reputation, usually by subjecting the person to public contempt, disgrace, or ridicule, or by adversely affecting the person's business. Basically, what they're saying is that by alleging that the professor had a romantic relationship with a student, that is basically a no-no. Of course, all universities, including the University of Idaho, have policies prohibiting that kind of relationship between a professor and a student for very good reasons. And they're saying that Ashley Gillard made statements basically alleging the professor broke that prohibition against relationships with students. And of course, that affects her job, because if the university were to give any credence to what Ashley Gillard is saying, the professor would lose her job. And so that affects her business, her trade. And I'm going to skip to the conclusion. The rest of it is dealing with the allegations of improper conduct between the professor and a student. In their conclusion, they say, for the reasons stated herein, Professor Schofield respectfully requests the court grant plaintiff's motion for summary judgment and hold Ms. Gillard liable for her defamatory statements as a matter of law. The evidence conclusively establishes that Ms. Gillard's statements defamed Professor Schofield. All that remains is for a jury to determine the amount of Professor Schofield's damages. So now let's talk about Ashley Gillard's bizarre response to this motion for summary judgment. And you're going to see, she just doesn't get it. I'm sure she's Googling all over the place to find pleadings that she can cut and paste from and adapt to this particular case. And I'm going to just cover like the parts that I think are most relevant so that we don't make this longer than it has to be. So in her introduction, quote unquote, she states, this litigation is a matter of determining the truth of the matter, whether or not Rebecca Schofield caused the deaths of the 4 students found on November 13, 2022. It's also important to determine if the court has subject matter jurisdiction over the plausibility of spiritual belief and practices. Well, she's not really using subject matter jurisdiction correctly here. Lastly, it's also important to determine if spiritual messages give rise to a cause of action for defamation. None of the above has been determined. So she's saying that what's defamatory are the spiritual messages. But that's not what the cause of action is based on. The cause of action is based on Ashley Gillard's making TikTok videos, making false claims against the professor. It has nothing to do with where Ashley Gillard believes she got the information from. It has to do with the fact that she's putting out information that's not true. Whether or not Casper the Friendly Ghost gave it to her or not is irrelevant in this matter. The fact that she repeated what Casper the Friendly Ghost told her is what matters. Additionally, defendant Ashley Gillard has never admitted to defaming. Okay, this is irrelevant. It doesn't matter whether she admits to defaming her, which she kind of has. It's a matter of whether she has defamed her, whether she admits it or not. You know, it's like if you're accused of a crime, whether you end up admitting it or not is irrelevant. It's what the evidence shows and what the court determines. Instead, she has continuously argued that this litigation was brought illegally, in bad faith to avoid Rebecca Schofield from being properly investigated for ordering the deaths of the students. So for some reason, Ashley Gillard thinks that the filing of a civil lawsuit somehow is influencing the police investigation. Well, you know, from my understanding and from what I had read about in the news, the police had already identified the suspect and had absolutely no reason to believe the professor had anything to do with this before this lawsuit was ever filed. It says that litigation has been complicated by the courts and the public's ignorance on the plausibility. Oh God, here we go. I'm not invalidating people who believe in tarot readings, but even people who believe it certainly can't think that somehow a tarot card reading is going to stand up as evidence in a court case. That's basically what I'm annoyed at here. It's not the fact that she does tarot readings so much as that she somehow thinks that what she gleans from a tarot reading is going to be evidence in court. Unless you have the evidence to back that up, it's nothing more than a statement. And so now she tries to justify why the court should give credence, which it can't even if it wanted to her tarot card readings. She's alleging that there's one instance where she supposedly made a reading for someone with tarot cards that predicted her husband's demise. She says, for example, Ashley Gillard conducted an intuitive tarot reading for someone on March 8th, 2023. It predicted the upcoming demise of the person's husband, who was otherwise healthy and young. Although the defendant hoped it wouldn't come true, the husband perished on October 24th, 2023. And it turns out that it wasn't an accident. He took his own life. That's still not evidence. I mean, you might say, ooh, isn't that coincidental or isn't that spooky? I'm not even sure what she's trying to say, because just because she alleges that she correctly predicted this man's demise using tarot cards, that doesn't mean that what she is alleging the tarot cards told her about Rebecca Schofield is correct. One instance, I mean, if she did this on a daily basis, then I might say, well, we should take a look at this. But again, without physical evidence supporting it, it's not evidence. You cannot convict someone because you say, well, I believe this, unless you have the evidence to show that, in fact, what you're saying is correct. You can't just make wild statements, even if you believe that they're true, because unless you have evidence that they're actually true, they're defamatory. And so she says, thus, because Gillard has experienced confirmation of the reliability of her intuitive tarot readings for the past 4 years, she has reason to believe that the messages she received about Rebecca Schofield are substantially true. Okay, she's only citing to one instance. If you have one outcome in a scientific experiment, if you can't replicate that outcome, the research is meaningless, because you have to be able to repeat it over and over to show that what your hypothesis is actually correct. One time where you get lucky does not substantiate that your hypothesis is definitely correct. Schofield and her attorneys attorneys with an apostrophe, have continuously lied about Ashley Gillard in every legal document they filed in this civil complaint. For example, plaintiff's motion for partial summary judgment, attorney Wendy Olson made a false statement that defendant Ashley Gillard posted content about the murder of the student to make money. Attorney Wendy Olson published that lie about Ashley Gillard knowing it was false because she has documents from TikTok provided to her after a subpoena dated June 20th, proving that defendant Ashley Gillard did not make any money by posting content on TikTok. Attorney Wendy Olson also promulgated several lies about Ashley Gillard in multinational news media. Additionally, Gillard has reason to believe this entire complaint was filed fraudulently and frivolously. The consideration of whether or not they're defamatory isn't whether she made money off of them. It's whether or not they're true. And there's no evidence to show that they're true. And so, arguably, her statements are defamatory. I don't care if she made $1 or $1 million. That's beside the point. Saying that the complaint was filed fraudulently and frivolously is just absurd, because I think the evidence is there. The statements aren't true. She made the statements. She put them out there. They're certainly causing damage to Professor Schofield. So that's not fraudulent or frivolous. So she's asking the court to deny the plaintiff's motion for a summary judgment and to heavily punish the plaintiff and her legal counsel with sanctions. I'm going to skip over her factual history. Recent history in the discovery phase of litigation to prevent defendant from obtaining physical evidence. The plaintiff and her attorney filed a motion to quash the summons Ms. Gillard served to Meta Platforms. Okay, so basically, when you want to get evidence from like a third party, you will send a subpoena, which will compel legally, because if the person doesn't want to cooperate, the subpoena is basically a legal device to compel the person to comply with your request. Ashley Gillard issued a purported subpoena on Meta with, Facebook, asking basically for every little bit of Professor Schofield's social media history. All of her posts, all of, messages, other things. A subpoena is not a blank check. You cannot just request anything you want from the other party. It has to be narrowly focused so that it's relevant to the case before the court. What Ashley Gillard was trying to do with this subpoena is get as much information about Professor Schofield to try to find something that would basically corroborate the false statements that she's made, that Ashley Gillard has made. You can't do that. You cannot use a subpoena to make your case. That's what we call a fishing expedition. And then she makes her quote-unquote argument. Substantial truth is a defense. Schofield has not proven that the statements Gillard made about her were false. There is no evidence to support any of the statements that Ashley Gillard has made. You need to have something to back that up. And I mean, your best case would be that the police would have some sort of evidence that would make Rebecca Schofield a suspect at the very least. They completely ruled her out. Gillard's intuitive messages are reliable. And she's basing that on that one tarot card reading she talked about, that somehow that one thing makes everything she predicts true. And then she goes on, she hashes this out about, why she was so accurate in this one instance. She's really harping on it. I'm not going to read it. In alignment with typical criminal behavior, she's now an expert on criminal behavior. An intent to hide their involvement in crimes, the plaintiff and attorney also. And she keeps bringing the attorney into this. It's like the attorney isn't working in conjunction with the professor. The attorney is representing the professor, and what the attorney does is use the information provided by her client to make the case in court. The attorney isn't acting independently. She's acting on the instructions and information provided by the client. So the attorney has absolutely nothing to do with her fantasies. And she's saying that they've blocked her discovery attempts to get evidence regarding the connection she had with the victims. And she's referring to her subpoena to Meta, asking for, everything including the kitchen sink about Rebecca Schofield so she could comb through it and maybe find something derogatory. And, she continues to harp on the fact that it's still a matter of discovery and investigation to expose the communication between Professor Schofield, the 4 students, and alleged co-conspirators. The document provided by the University of Idaho admits they never investigated the claims. The University of Idaho, if that's true, I don't even know what she's talking about, but if they didn't investigate Ashley Gillard's nonsense claims, it's because there's no evidence. You don't investigate until you find something. You investigate because you have a suspicion that something might be true. I'm not going to get into every single detail because you get the gist, but this particular part I thought was interesting. She says, Ashley Gillard says, the complaint is barred by qualified privilege. Now, privilege usually is like between attorney and client, doctor and patient, priest and communicant, things like that. But Ashley Gillard, this is what she interprets it to mean. Gillard conducted the psychic investigation and exposed the results online because she wanted to help solve the killings. An intuitive reading revealed that Schofield would get away with the crime if Gillard did not get involved. So thank God for Ashley Gillard. Therefore, Gillard posted the information she gathered from the intuitive tarot readings online for exposure. Exposure for herself, yeah. Gillard did not know how she could make a positive impact on the case of the deaths of the students as an outsider. Outsider? She has nothing to do with it. Mind your own freaking business. You're not even in the state, for crying out loud. She posted the content with the intent to gain exposure, again, for herself, in my opinion, so that she could get the attention of the investigators and help solve the case. The judicial privilege immunizes a party from civil liability for statements made during judicial proceedings. Okay, again, people, don't ever be your own lawyer, especially not in a case as complicated as this. First of all, there is no privilege. She's trying to say that the statements she made were in the course of a police investigation, therefore they were made during a judicial proceeding. A police investigation isn't a judicial proceeding. Judicial proceeding implies something going on in court. I'm not going to go through this because it's just, she just doesn't, like I said, she doesn't get it. She does not understand the law. And she's done herself a terrible disservice by not getting counsel to help her. Basically, Ashley Gillard has sunk her own ship. She doesn't even have the tiniest bit of credible evidence to lend any kind of legitimacy to what she said. The fact that she tried to help solve the crime, it might make a good TV show, but the reality is the police didn't need her help because they had the evidence they needed to arrest the suspect. Whether or not Ashley Gillard agrees with the evidence doesn't matter. Just because she chooses to impose herself into the police investigation does not make her somehow a part of the investigation. And she says a whole bunch of nonsense, and she says that, the litigation and the court basically are not entitled to any respect, which is, I'm sure, winning big points with the judge. And then her prayer for relief, which is like the cherry on top of the shit cake. She's asking the court to award Ashley Gillard all court-related fees. As far as I know, she hasn't had to pay anything. She doesn't have a lawyer. What fees is she talking about? She didn't have to pay to file anything. The plaintiff paid to file the case. I don't know what she's talking about. And she wants sanctions pursuant to Rule 11C in the amount of $1 million. Certainly a number that she pulled out of her ass because she doesn't have any evidence, I imagine, to support where she's getting that figure from. And that's where we stand. My prediction? I think the motion for summary judgment gets granted because I agree with the plaintiff that what is there left to adjudicate here? If you take the admissions as admitted and looking at the absolute lack of any supporting evidence on Ashley Gillard's part, what is there to decide at trial? And I think Ashley Gillard is going to have judgment against her, although good luck, Professor Schofield, with collecting a dime from her because something tells me she's what we call judgment proof. But clearly, I think the professor knows that from the outset. This is all an exercise to clear her name and to punish Ashley Gillard and basically also to make an example of her so that more fools on TikTok don't decide to become armchair detectives and use their ayahuasca hallucinations as, that's a joke, by the way, as an investigative tool. Okay? So let me know what you think down below. But again, that's my prediction. That's my opinion on the whole mess. Okay, so as promised, those of you who are still with me, I'm going to do a taste test. I've got 2 different flavors of Oompaville's Sour Boys candy. And again, I'm not sponsored. I paid for these. I ordered them off their website. I wanted to see what it tastes like. I've seen Oompaville talk about this stuff for a long time, and I watched Caleb talk about how he got screwed by the guy who was helping him get the equipment to make his candy, which is a really terrible story. And I'm glad that he still is going forward with his dream, even though that guy almost destroyed it. So, okay, the first one we're going to try, it's strawberry. So it's the Dragon Edition. So let's open this up. It smells good. All right, let's see. Oh, it's like a giant fruit roll-up. It's not exactly what I was expecting. God, it reminds me of something. It's like a flavor from my childhood that sort of underlying all of this. I can't think of what it is right now, but that's pretty good. Kudos for the strawberry flavor. Don't tell anyone, but I'll probably finish that package later. It's not too sour either, so it's sort of, it's I like it. Anyway, I like that one. So this is the Oompa Edition Sunshine Slap, and I think this was like a limited thing that they did, if I remember. that it was like a limited flavor. I don't know what it smells like. I can't decide what it smells like, so let's see what it tastes like. My sense of smell isn't picking up on any dominant scent. My taste buds are confused. I don't know what I'm tasting. I almost wanted to say like mango, maybe mango. Well, I'm glad to see that they use cane sugar. I absolutely hate high fructose corn syrup. I try not to buy anything with high fructose corn syrup. Sugar all the way, If you're going to eat sweet, make it just real sugar. I'm eating another piece of that one because I still haven't decided what I'm eating. Anyways, my verdict, very good. I have nothing bad to say. I like the strawberry probably better. Not that I don't like this one, but I love strawberry. So strawberry and raspberry are like my two favorite flavors. But kudos to Oompa 2 thumbs up from MadCatster. I like it. So now, those of you who've stuck this far, let me just tell you quickly about my little squirt. And this story is why I'm always so overflowing with thanks for our Patreon patrons and our channel members. My little squirt, who's sleeping right now, I would hold him up. I call him, his name's Olivier. I've introduced him to you before. I call him Squirt because he's a runt. He's black and white. His fur is as soft as literally as an Angora rabbit. It's just so soft. And he's very chatty, and he's, got a little face, but every night he sleeps on the pillow next to me, curled up, without fail, and has to be like right near me. He has chronic, like sinus stuff, and he sneezes, and it goes through like cycles, and there's not really anything that I can do about it. I used to bring him to the doctor all the time when he would have these sneezing fits, and with the exception of occasionally giving him a tiny bit of antihistamine if it's really too bad, and please don't do that unless you talk to your vet. There's not really anything that I can do. So I feel bad, but he's very sweet. He's very lovable. However, what goes along with those sinus issues is sometimes ear infections. And he has chronic ear infections, which I take him to get treated. But he will itch his ears, and I know, like, I have drops I'll give him and I'll put in, and I'll use a Q-tip to try to clean it out. Last week, he had in the ear that doesn't usually bother him. All of a sudden, at night, he started really going at his ear and really scratching it. And so I put drops in, I massaged his ear, got him calmed down. He went to sleep, and it didn't seem to bother him all night. I got up the next morning, he ate his breakfast. I went to court. I came home after lunch. I went up to check on him, and his little outer ear was, instead of being thin like it should be, it was like this thick. And I freaked out, and I called the vet right away. And they're always really good to me, as I've said many times. So unfortunately, I couldn't bring him right then, but they said it sounded like it was a hematoma, which apparently is blood pooling up under the skin, and it wasn't like life threatening. So they scheduled me for first thing in the morning. So first thing in the morning, I brought him in, and the doctor said, I've got to do surgery because I can't just treat this without putting him under and operating on the ear and cleaning it out. So unfortunately, my poor little boy had to go through that. He's doing fine though. He's still got his stitches in, but it's fairly well healed now. And I brought him back today for a follow up, and they went in and tested his ear. They did a swab of his ear and tested it, and they found there was still bacteria and there was still yeast in there. So they, flushed him out again and gave him more medicine to try to clear it up so that he doesn't itch it. But you will not believe what it cost me to have them go in and drain that one. Thank God it wasn't like major surgery. $800. I kid you not, to drain that ear. $800. So when I say that I really appreciate our Patreon patrons and our channel members, I mean it. Because what you guys pledge each month goes to help offset the cost. I mean, it doesn't cover the bills, but it certainly helps. So thank you guys. And I'll put up, thank you to all of our Patreon patrons. I'll put it up here, as I always say. And here's your dollars at work. I mean, they're always at work because I've told you before, I pay my vet twice a month. Every month. Never ending. So you help every month with the payments I make to my vet. But this particular instance, I'm grateful to have your support. I really am. So thank you to all our channel members and all of our Patreon patrons. And if you'd like to become a Patreon patron, the link's down below, or a channel member, we'd appreciate it. We appreciate you. Please subscribe. As I said earlier, we are almost to 30,000. We're only about 1,000 short. Let's get to 30,000 before the end of the year, please. So like and subscribe. I've got another video coming, and I had looked into the Ace family's lawsuit, and there might be something to report there. Otherwise, I've got something else to report on. But in the interim, as I always say, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.